Marriage Bill, as introduced in the National Assembly, proposed Section 76, explanatory summary of Bill and prior notice of its introduction, published in Government Gazette number 49887 of 13 December 2023. Chapter 1, Definitions and Objects of Act. Definitions. In this Act, unless the context otherwise indicates, Civil Union Act means the Civil Union Act 2006, Act Number 17 of 2006. Court means any division of a High Court of the Republic of South Africa contemplated in Section 6(1) of the Superior Courts Act 2013, Act Number 10 of 2013, or a court for a regional division contemplated in Section 29 1B of the Magistrates' Courts Act 1944, Act Number 32 of 1944. Criminal Law, Sexual Offences and Related Matters Amendment Act means the Criminal Law, Sexual Offences and Related Matters Amendment Act 2007, Act Number 32 of 2007. Customary marriage means any marriage entered into in terms of the Recognition of Customary Marriages Act before the commencement of this Act. Department means the department responsible for home affairs. Director General means the Director General of the department. Magistrate has a similar meaning ascribed to it in Section 1 of the Magistrates Act 1993, Act Number 90 of 1993. Marriage means any marriage contemplated in Section 3. Marriage Act means the Marriage Act 1961, Act Number 25 of 1961. Marriage Officer means any person designated as a marriage officer in accordance with Chapter 4 of this Act. Matrimonial Property Act means the Matrimonial Property Act 1984, Act Number 88 of 1984. Minister means the member of cabinet responsible for home affairs. Monogamous marriage means a marriage where a person is married to only one spouse at a time. Polygamous marriage means a marriage in which a male spouse has more than one wife at the same time in terms of custom or religion. Population register means the population register contemplated in Section 5 of the Identification Act 1997, Act Number 68 of 1997. Prescribed means prescribed by regulations. Recognition of Customary Marriages Act means the Recognition of Customary Marriages Act 1998, Act Number 120 of 1998, and this Act means the Marriage Act 2023 and includes the regulations. Objects of Act. The objects of this Act are to provide for the recognition of marriages, provide for the requirements of marriages, provide for the designation of marriage officers, and provide for the solemnization and registration of marriages. Chapter 2, Recognition of Marriage and Proof of Identity. Recognition of Marriage. The following marriages are recognized as a marriage: any subsisting marriage concluded in terms of the Marriage Act, any subsisting civil union concluded in terms of the Civil Union Act, any subsisting customary marriage concluded in terms of the Recognition of Customary Marriages Act, any subsisting monogamous or polygamous marriage concluded before the commencement of this Act, which marriage was not recognized under any other law, and any monogamous or polygamous marriage entered into after the commencement of this Act, which complies with the requirements of this Act. proof of identity. The age of the prospective spouses to a marriage must be determined by means of a birth certificate contemplated in Section 9(7) of the Births and Deaths Registration Act 1992, Act Number 51 of 1992, by means of an identity card as defined in Section 1 of the Identification Act 1997, Act Number 68 of 1997, or, in the case where one or both prospective spouses are foreigners, by means of a valid passport and a valid visa or permit. Chapter 3. Requirements for monogamous and polygamous marriage. Requirements for monogamous marriage. For a monogamous marriage, entered into after the commencement of this Act, the prospective spouses must both be 18 years of age or older on the date of entering into a marriage, must give consent to enter into a marriage, and must be of sound mind. For a marriage entered into in accordance with custom or religion to be valid, it must, in addition to the requirements referred to in subsection 1, be negotiated and entered into or celebrated in accordance with the respective custom or religion. Save as provided for in section 6.2, no spouse in a monogamous marriage shall be competent to enter into a further marriage under this Act during the subsistence of such monogamous marriage. Any foreigner who wishes to enter into a marriage whilst resident in the Republic must provide an apostilled letter of non-impediment for the relevant authority of his or her country of origin. Any marriage entered into after the commencement of this Act, which does not comply with the requirements of this section, is null and void. Requirements for polygamous marriage. For a polygamous marriage entered into after the commencement of this Act, the prospective spouses must both be 18 years of age or older on the date of entering into a marriage, must give consent to enter into a marriage, and must be of sound mind. A husband in a marriage who wishes to enter into a further marriage after the commencement of this Act must obtain written consent from his wife, or, in the case where there is more than one wife, his wives, as the case may be, provided that in the case of a royal family, the consent must be in accordance with the customs and traditions of such family, and make an application to the court to approve a written contract which will regulate the future matrimonial property system of his marriages. For purposes of this section, a husband refers to a male person and excludes a male partner in a same-sex marriage. When considering the application in terms of subsection 2b, the court must, in the case of a marriage which is in community of property or which is subject to the accrual system, terminate the matrimonial property system which is applicable to the marriage, and effect a division of the matrimonial property, ensure an equitable distribution of the property, and take into account all the relevant circumstances of the family groups which would be affected if the application is granted. The court may allow further amendments to the terms of the contract, grant the orders subject to any condition it may deem just, or refuse the application if in its opinion the interests of any of the parties involved would not sufficiently be safeguarded by means of the proposed contract. All persons having a sufficient and direct interest in the matter, and in particular the applicant's existing spouse or spouses and the prospective spouse, must be joined in the proceedings instituted in terms of subsection 2b. If a court grants an application contemplated in subsection 2b, the registrar or clerk of the court must furnish each spouse with an order of the court, including a certified copy of the contract, and cause such order and a certified copy of the contract to be sent to each register of deeds of the area in which the court is situated. Chapter 4. Designation of marriage officers. Ex officio marriage officers. Every magistrate shall, by virtue of his or her office, and so long as he or she holds such office, be a marriage officer for the district or other area in respect of which he or she holds office. The minister, or any employee in the public service authorized by the minister, may designate any employee in the department or the diplomatic or consular service of the Republic to be, by virtue of his or her office, and so long as he or she holds such office, to be a marriage officer, either generally or for any country or area. Designation of other persons as marriage officers. Any person may, in the prescribed manner, apply to the Director General to be designated as a marriage officer in terms of this Act. The person contemplated in subsection 1, who wishes to be designated as a marriage officer, must be a South African citizen or a permanent resident, be a fit and proper person to act as a marriage officer, be of a sound mind, have successfully completed the prescribed training to be designated as a marriage officer, not have been convicted in the Republic or elsewhere and imprisoned without an option of a fine for an offence involving theft, fraud, forgery, perjury, misrepresentation, or dishonesty, not have been convicted of any serious offence and sentenced to more than 12 months imprisonment without an option of a fine, not be an unrehabilitated insolvent, or must not have been removed from any office on account of gross misconduct involving dishonesty. The person contemplated in subsection 1 must hold a responsible position in any religious institution, secular organization, traditional council as defined in Section 1 of the Traditional and Khoisan Leadership Act 2019, Act Number 3 of 2019, or Khoisan Council as defined in Section 1 of the Traditional Khoisan Leadership Act 2019, Act Number 3 of 2019. The Director General or any employee in the department authorized thereto by the Director General may limit the authority of any marriage officer to solemnize marriages within a specific area for a prescribed period and for a specific religion, custom, or other beliefs. Every designation of a person as a marriage officer must be in writing and specify the date as from which it has effect and any limitation to which it is subject to. Deemed marriage officers. Whenever any person has acted as a marriage officer during any period or within any area in respect of which that person was not a marriage officer under this Act, and the minister or any employee in the department authorized thereto by the minister is satisfied that such person did so in good faith under the belief that he or she was a marriage officer during that period or within that area, he or she may, in writing, direct that such person was for all purposes deemed to have been a marriage officer during such period or within such area and duly designated as such under this Act, as the cause may be. Whenever any person acted as a marriage officer in respect to any marriage while that person was not a marriage officer, and any or both parties to the marriage in good faith believe that such person was a marriage officer, The minister or any employee in the department authorized thereto by the minister may, after having conducted such inquiry as he or she may deem fit, direct that such person be deemed to have been duly designated as a marriage officer in respect of that marriage. A marriage solemnized by a person who, in terms of this section, is deemed to have been duly designated as a marriage officer shall be as valid and binding as it would have been if such person had been duly designated as a marriage officer, provided that such marriage was in every other respect solemnized in accordance with the provisions of this Act or any prior law, and there was no lawful impediment to the marriage. A person deemed to be a marriage officer in terms of this Act is not relieved from liability to any prosecution contemplated in Section 17 of this Act. Revocation and suspension of designation as marriage officer. The Director General or any employee in the department authorized by the Director General may, in writing and on the ground of misconduct for any good cause, revoke or suspend the designation of any person as a marriage officer. Any person affected by the decision contemplated in Section 1 may appeal to the minister. The minister may, after considering an appeal referred to in paragraph A, confirm, set aside, or vary any decision or make any appropriate decision the minister deems fit. The Director General may publish such revocation in the Gazette. Chapter 5. Solemnization and Registration of Marriage. Solemnization of Marriage. A marriage officer may solemnize a marriage at any place within the Republic and at any time in accordance with any mode of solemnization or in accordance with any religious, secular, or customary practice. A marriage officer may not solemnize any marriage where the prospective spouses and two witnesses are not present during the solemnization of the marriage, provided that where the presence of both spouses is not required in terms of the tenets of any custom, religion, or belief, the marriage may be solemnized in accordance with such custom, religion, or belief. A marriage officer may not solemnize a marriage unless the prospective spouses produce to the marriage officer the proof of identity contemplated in Section 4. Any person designated as a marriage officer, other than ex officio marriage officers contemplated in Section 7, may not be compelled to solemnize any marriage which is against his or her conscience, religion, or belief. A marriage officer may not solemnize a marriage which does not comply with the requirements in Section 5 or Section 6, and must inquire from the prospective spouses whether the prospective spouses consent to the solemnization of the intended marriage, there are no lawful impediments to the solemnization of the intended marriage, and the prospective spouses are not related to each other on account of consanguinity, affinity, or an adoptive relationship as referred to in Section 12 of the Criminal Law Sexual Offences and Related Matters Amendment Act. The spouses, marriage officer, and two witnesses must sign the prescribed marriage register in each other's presence immediately after the solemnization of the marriage, and a signed copy thereof must be provided to the spouses. Objection to marriage. Any person who wishes to raise an objection to a proposed marriage may, in writing or orally, and before the solemnization of the marriage, lodge such objection with the marriage officer who is to solemnize the marriage. Upon receipt of any such objection, the marriage officer must inquire into the grounds of the objection, and if the marriage officer is satisfied that there is no lawful impediment to the proposed marriage, he or she may solemnize the marriage in accordance with the provisions of this Act. Or, if the marriage officer is not satisfied, the marriage officer may refuse to solemnize the marriage. Registration of marriage. Spouses must ensure that their marriage is registered with the department. Marriage officers must, in the prescribed form and manner, keep a record of all marriages solemnized by them. Within 14 days of solemnization of a marriage officer must submit the prescribed marriage register and all other prescribed records to the Director General for registration of a marriage. The Director General must register the marriage and include the details of the marriage in the population register. A marriage entered into before the commencement of this Act, which is not registered in terms of any other law, must be registered within a period of 12 months after commencement of this Act, or within such longer period as the Minister may from time to time prescribe by notice in the Gazette, or entered into after the commencement of this Act, must be registered within a period of 14 days after the conclusion of the marriage, or within such longer period as the Minister may from time to time prescribe by notice in the Gazette. The Director General must, if satisfied that the spouses concluded a valid marriage, register the marriage and record the identity of the spouses, the date of the marriage, and any other prescribed information in the population register. The Director General must issue to the spouses a certificate of registration, bearing the prescribed particulars. If a marriage is not registered, any person who satisfies the Director General that he or she has a sufficient and direct interest in the matter may, in the prescribed form and manner, apply to the Director General to register the marriage. If the Director General is satisfied that a valid marriage exists or existed between the spouses, the Director General must register the marriage and issue a certificate of registration as contemplated in subsection 6b. If the Director General is not satisfied that the spouses entered into a marriage, the Director General must refuse to register the marriage. A court may, upon application made to that court, and upon investigation instituted by that court, order the registration of any marriage, or the cancellation or rectification of any registration of a marriage effected by the Director General. A certificate of registration of marriage issued under this section or any other law providing for the registration of marriages constitutes prima facie proof of the existence of the marriage and of the particulars contained in the certificate. Chapter 6: Proprietary Consequences and Dissolution of Marriage. Equal legal status and capacity of spouses. All spouses in a marriage have, on the basis of equality and subject to the matrimonial property system that applies to the marriage, full legal status and capacity, including the legal capacity to acquire assets and to dispose of them, to enter into contracts and to litigate, in addition to any rights and powers that the spouses may have under any other law. Proprietary consequences of marriage. The proprietary consequences of a polygamous marriage entered into before the commencement of this Act, which was not registered in terms of the Recognition of Customary Marriages Act or any other law, and where the spouses do not intend to enter into further marriages, continue to be governed by law applicable to such marriage or the agreement concluded between the spouses. Prior to solemnization of a marriage, the prospective spouses must voluntarily choose the matrimonial property system that will apply to their marriage. Where the matrimonial property system chosen by the prospective spouses is out of community of property, with or without a quarrel, the spouses must, prior to the registration of their marriage, conclude the prescribed antenuptial contract and comply with Chapter 7 of the Deeds Registries Act 1937 Act Number 47 of 1937, provided that, in the case where the antenuptial contract had not yet been registered as contemplated in Section 87 of the Deed Registries Act 1937, Act Number 47 of 1937, the prospective spouses must provide the prescribed proof from the notary or legal practitioner that an antenuptial contract has been concluded. Chapter 3 and Sections 18, 19, 20, and 24 of the Chapter 4 of the Matrimonial Property Act is applicable in respect of any marriage which is in community of property as contemplated in subsection 2. Spouses in a marriage entered into before or after the commencement of this Act may apply to a court jointly for leave to change the matrimonial property system which applies to their marriage or marriages, and the court may, if satisfied that there are sound reasons for the proposed change, sufficient written notice of the proposed change has been given to all creditors of the spouses, and no other person will be prejudiced by the proposed change, order that the matrimonial property system applicable to the marriage or marriages shall no longer apply, and authorize the spouses to the marriage or marriages to enter into a written contract in terms of which the future matrimonial property system of their marriage or marriages will be regulated on conditions determined by the court. In the case of a husband who is a spouse in more than one marriage, all persons having a sufficient and direct interest in the matter, and in particular the applicant's existing spouse or spouses, must be joined in the proceedings. Section 21 of the Matrimonial Property Act is applicable to a monogamous marriage entered into after the commencement of this Act. Dissolution of marriage. A marriage may be dissolved by death of one or both spouses, or by a court by a decree of divorce as contemplated in the Divorce Act 1979, Act Number 70 of 1979. Chapter 7. Offences and Penalties. Offences and Penalties. Any person who enters into a marriage with a person who is not at least 18 years of age, or any person other than a child who participates knowingly in such a marriage, shall be guilty of an offence and liable on conviction to a fine, or in default of payment to imprisonment for a period not exceeding 5 years, or to both such fine and such imprisonment. Any person who makes any false representation or false statement, knowing it to be false, shall be guilty of an offence and liable on conviction to the penalties prescribed by law for perjury. Any person who knowingly solemnizes a marriage or registers or fails to register a marriage in contravention to the provisions of this Act shall be guilty of an offence and liable on conviction to a fine of imprisonment for a period not exceeding 5 years, or both to such fine and such imprisonment. Any person who solemnizes or registers a marriage, knowing or has reason to suspect that the capacity of a prospective spouse to freely consent to the marriage is impaired due to an intellectual disability, or by being under the influence of alcohol or any other intoxicating substance, shall be guilty of an offence and liable on conviction to a fine or imprisonment for a period not exceeding 6 months, or to both such fine and such imprisonment. A prospective spouse who enters into a marriage knowing that the other prospective spouse is related to that prospective spouse on account of consanguinity, affinity, or an adoptive relationship, as referred to in Section 12 of the Criminal Law, Sexual Offences and Related Matters Amendment Act, shall be guilty of an offence and liable on conviction to a sentence which a court may impose, as provided for in Section 276 of the Criminal Procedure Act 1977, Act Number 51 of 1977, which that court considers appropriate and which is within the court's penal jurisdiction. A marriage officer who delegates the function to solemnize marriages to a person who has not been designated as a marriage officer or knowingly assists a person who is not designated as a marriage officer to solemnize a marriage shall be guilty of an offense and liable on conviction to a fine or imprisonment for a period not exceeding 10 years, or to both such fine and such imprisonment. Any person who knowingly, whilst not being designated as a marriage officer, solemnizes a marriage which he or she is not authorized to solemnize under this Act, or solemnizes a marriage which, to his or her knowledge, is legally prohibited, shall be guilty of an offense and liable on conviction to a fine or imprisonment for a period not exceeding 5 years, or both to such fine or imprisonment. Chapter 8. Miscellaneous. Regulations. The minister must make regulations relating to the form and content of certificates, notices, affidavits, and declarations for the purposes of this Act, the fees payable for any certificate issued or any other act performed in terms of this Act, the form, content, and procedure for an application for the registration of a marriage, matters to be taken into account in determining whether to proceed with the registration of a marriage, the form, content, and procedure for an application submitted to the minister by any person or any officer in the department authorized for the designation as a marriage officer, matters to be taken into account in determining whether to designate a marriage officer with or without limitations, the duration and renewal of a designation as a marriage officer, the conditions that may be imposed on the grant or renewal of a designation as a marriage officer, the training of persons to be designated as marriage officers, the fees in respect to the grant of or renewal of a designation as a marriage officer, the fees for the training of a person to be designated as a marriage officer, the circumstances in which a designation may be granted, renewed, suspended, or revoked, an appeal of any decision to refuse, grant, or renew a designation as a marriage officer. The minister may make regulations relating to any matter which by this Act is required or permitted to be prescribed, or which the minister considers necessary or expedient to prescribe for purposes of this Act, or that the provisions of this Act may be effectively administered. The regulations may prescribe penalties for a contravention of the provisions thereof, for a fine not exceeding the amount that, in terms of the Adjustment of Fines Act 1991, Act Number 101 of 1991, may be imposed as an alternative to imprisonment for a period of 6 months, or, instead of a payment of a fine referred to in paragraph A, imprisonment for a period not exceeding 6 months. Any regulation made under subsection 1, which may result in financial expenditure for the state, must be in consultation with the Minister of Finance. Amendment of laws. The laws specified in the second column of Schedule 1 are hereby amended to the extent set out in the fourth column thereof. Repeal of laws. The laws specified in Schedule 2 are repealed to the extent set out in the fourth column thereof. Chapter 9. Transitional Provisions. Existing Marriages. The commencement of this Act shall not affect a marriage that was valid in terms of any prior law, and such marriage shall continue to be valid under this Act. Existing marriage officers. Any person who, in terms of the Marriage Act, has been designated as marriage officer shall continue to be a marriage officer until his or her designation expires or is revoked by the Director General for any valid reason. Any designation referred to in subsection 1 may not be renewed in terms of this Act. Every magistrate who, in terms of the previous Act and by virtue of his or her office, was a marriage officer for the district or other area in respect of which he or she holds office, continues to be a marriage officer in terms of this Act. Chapter 10. Short Title and Commencement. Short Title and Commencement. This Act is called the Marriage Act 2023 and comes into operation on a date fixed by the President by proclamation in the Gazette.